Thanks everybody for coming on this chilly Friday to this wonderful installation of the Emerging Trends in Criminal Justice seminar series, which is organized by myself, Professor Heidi Matthews, Professors Francois Tanguay-Renaud, and also Palma Pachoco, and of course run out of the Nathanson Center on Transnational Human Rights, Crime and Security. This talk is an installation in the second year of the series, which so far has been a great success. And the series itself aims to engage with the most pressing questions of criminal justice, law, and policy today, both domestically and globally. Today we have the great pleasure of welcoming Alice Ristroph, who is a professor of law at Brooklyn Law School, where she teaches and writes in criminal law and procedure, constitutional law, and political theory, with particular emphasis on issues of violence and resistance. Her recent work examines laws that regulate state violence, focusing especially on the law's distribution of risks of physical harm. And today, Professor Ristroph will be presenting her paper, which I believe is still a work in progress, so we'll be looking forward to the discussion today, and it's entitled An Intellectual History of Mass Incarceration. So just a word about format. We will do the talk, which is being recorded. We then need just about a minute to change battery. We're going to have the question and answers, and so just keep in mind that because the talk is being recorded from the point of view of your questions. So if you would join me in thanking Professor Ristroph, I will hand it over to her.
Thank you so much, Heidi and Francois, for having me. I am so happy to be here in Canada. I consider myself an honorary Canadian, even though that honor has not formally been bestowed upon me. I have a Canadian partner who was here at the Nathanson Center earlier to speak, and I have children with dual U.S. And Canadian citizenship. So as the mother of Canadians, I consider myself partly Canadian. And whenever we arrive here, we always say, "Oh, it's so nice to be in a civilized country." And speaking of civilized or not civilized countries, speaking of my own homeland, the United States, I do want to say I feel a little bit of regret about giving you a paper today that is such a deeply American study of American law and American institutions. But I'm hopeful that maybe your slight distance will give you a vantage point that I don't have and might help me refine the arguments in this paper. So let's think about American exceptionalism first. The United States claims to be exceptional in many ways, and I think is exceptional in some ways, although the claims and the realities don't always line up. I think there is undoubtedly a kind of exceptionalism that characterizes criminal law in the United States right now. First of all, just the rates of incarceration. And when we speak about incarceration rates, I always want to add to that conviction rates and rates of other kinds of criminal law interventions. Because I think that if we focus only on the numbers of people in prison, then we actually understate the scale of the reach of American criminal law and don't identify all the ways in which American criminal law is exceptional. So we think not only of actual prisoners, but also of people held in jails and other facilities. If we think of just rates of conviction, and by rates of conviction, I don't mean the rate at which someone who is charged is then convicted. I just mean the rate across the American population as a whole at which someone has a criminal conviction at some point. Then it's clear, if we look at sort of these other measures, in addition to the actual prison population, it's clear that the United States is exceptional in the scale and reach of its criminal legal system, in the number of its interventions and the rate at which those interventions, be it mere conviction or conviction plus imprisonment, America is exceptional in that way. And it's exceptional in comparison to other nations, but also exceptional in relation to its own history. So I want to begin by just talking a little bit about historical exceptionalism of American criminal law, because I think that in the current discourse about American criminal law and how to diagnose the problem, what we should do about it. I mean, I will say happily, I think in the past 5 or so years, there's been a marked change in US discourse with regard to criminal law, I would say a much sort of wider sense of crisis and of dysfunction and of a sense that our criminal legal system is shameful and we should do something about it. But in that discourse, there is a sense, a discussion of exceptionalism, a sense that what we see in the United States right now is radically different from the past of criminal law in the United States. That we see a system which has these exceptionally high incarceration rates, but also has many other things that people criticize, like very broad substantive prohibitions that make tons and tons of things criminal, and some of those prohibitions are worded in very vague ways so that there's a lot of ambiguity about what exactly they prohibit. And these broad and vague substantive prohibitions create a world in which enforcement officials, police and prosecutors, have a tremendous amount of discretion about who to actually prosecute, arrest, or prosecute and impose punishment upon. So in the US discourse on historical exceptionalism, the breadth of substantive criminal law and the prevalence, the profound role of enforcement discretion are often cited as part of America's current crisis. Other aspects of criminal law in the United States that are often cited as dimensions of the crisis include the disparities in the targets of criminal law enforcement, the extent to which the enforcement officials who possess so much discretion are using that discretion disproportionately against people of color and against poor people. And so these racial and socioeconomic disparities are also seen as part of the crisis. So on historical exceptionalism, one of the first points I want to make in this paper is that frankly, American criminal law is not so historically exceptional today as much of the hand-wringing about our present crisis would suggest. It is true that the rates of intervention, and I say rates of intervention, I mean rates of incarceration, rates of arrest, rates of convictions, that don't result in incarceration. It is true that the rates at which criminal law intervenes into people's lives in profound ways have increased. Those are historically exceptional, much higher than they have been at previous points in United States history. But the other things that we decry as part of the crisis, the broad substantive laws, the tremendous discretion held by enforcement officials, the racial and socioeconomic disparities, those things have been characteristic of criminal law in the United States from the earliest years of the country. So that's sort of part one of this project, is just to try to identify the ways in which criminal law in 2019 in the United States is and is not historically exceptional. I think one of the other points of continuity that I want to emphasize is that the sense of the kind of general sense of criminal law as not being what we want it to be, not achieving what we want it to achieve. That also is fairly continuous, although again there's sort of a new intensity to the complaints of crisis in the past 5 years or so. But if you look back at discourse on criminal law in the United States in the 1920s and around the turn of the century, from the 1800s to the 1900s, if you look back into the 19th century, there is a fair amount of discourse of crisis and collapse, and American criminal law is a disgrace, and too many criminals get away with things, particularly I think during the Prohibition era. there was a really profound sense of the sort of the corrupt nature of law enforcement during Prohibition, and indeed that perception is part of what led to the repeal of Prohibition in 1933. So I think it's important to kind of see the points of continuity and the points of change in our criminal justice practices, but I make that as a sort of, I make those observations to sort of set the stage for the main inquiry of this project, which is really more a question about ideas, about the ideas that we hold about criminal law, our expectations of it, our view of what it should look like, our view of what it can accomplish, our descriptions of the way that it does in fact operate. That's what I mean by this sort of intellectual framework or a paradigm of criminal law. What is the way that we understand criminal law in the United States? And I think it's important here to note that this very inquiry, the very idea of an intellectual paradigm for criminal law, was an invention of probably the 1930s, 40s, 50s in the United States. Before that, American legal scholars had offered, profound rethinkings of contracts or evidence or property law, various fields of private law. There were leading thinkers who published treatises, and those fields had a certain dignity and respect in American law schools in the first half of the 20th century. Criminal law was seen as an intellectual backwater. That's a quote. It was seen as a field that was, sort of chaotic and disorganized, and there was nothing interesting to say about it if you were a profound jurisprud thinking big thoughts about law. The law schools did not encourage people to go into the practice of criminal law. Some law schools barely wanted to have criminal law in their curriculum at all, and they didn't want to have criminal law scholars on their faculties. And it was just not seen as a field in which there was kind of lively intellectual work being done, rich theoretical arguments being made about the structure or function or paradigms of this field of law. And in the paper, I sort of use a lot of quotations and writings from influential legal thinkers from the 1920s and 30s, and folks like Roscoe Pound, Wigmore at Northwestern, James Barr Ames. It's kind of influential early 20th century deans of fancy law schools. Noticed and identified the status of criminal law as a kind of intellectual backwater, and decried it, and kept calling upon the legal academy to produce someone the equivalent of Williston on contracts, but someone like that for criminal law. And it took some time, but beginning around, I think, 1940, there emerged in American law schools some very influential texts produced by influential scholars that attempted to fill this gap, to offer a paradigm for criminal law, a sophisticated legal theory, and not just a legal theory, but a sort of sophisticated pedagogical approach that would bring dignity and respectability, intellectual respectability to the field of criminal law. So that's part of the story I tell. This is part 2 of the paper, if you did look at the draft. I spend some time thinking about one particular influential textbook that was first published in 1940 by Jerome Michael and Herbert Wexler. And that casebook, although it just came out in one edition and then they never updated it, but that casebook presented a pedagogical way of teaching criminal law, which was very different from what had come before, and which remains the model in American law schools to this day. That book moved away from teaching criminal law in a way that sort of really integrated a lot of sort of practical materials and judicial decisions, a way that might include, police reports or an indictment alongside a judicial opinion. I think that the separation of substantive criminal law as the place where we define what is criminal, and criminal procedure as the things that prosecutors do, or that rules for police officers or adjudicative procedures. That separation didn't occur in American law school classrooms until about 1940. And then in 1940, this casebook, again, really sort of pushed out the process, the procedures, the enforcement issues, and took substantive criminal law, the definitions of crimes, as itself a independent field of law that should be taught, and it tried to give it some philosophical and analytical rigor to identify certain concepts. It also, this casebook also, sort of proclaimed the dignity of this enterprise. So the Michael and Wexler casebook has a few features, which I talk about in the paper. It teaches criminal law almost entirely through the crime of homicide. Other crimes are not much discussed. The various concepts such as mental states or causation are taught primarily through the crime of homicide. Throughout the book, there's a very heavy emphasis on mental states and intentions and the way that criminal law distinguishes between different kinds of different degrees of bad intentions. The casebook also is kind of openly normative and inviting students to think about what this field of law should accomplish and how a wise legislature would design substantive laws, substantive prohibitions to best serve society. It's not a casebook that's really designed for practitioners. I think that Michael and Wexler were kind of explicit about that. Even as they tried to claim a dignity for criminal law, they still weren't that eager to send students out to be prosecutors or criminal defense attorneys. But it did want them to think again about the wise legislature, how a wise legislature would define criminal prohibitions to serve the important functions of criminal law. And that last point, the important functions of criminal law, was part of this paradigm here, emerging through this new casebook and new criminal law course, but also emerging in criminal law scholarship. So in addition to looking at pedagogical materials, I look at influential articles and scholarship from this period. A theme across the pedagogical materials and the scholarship is the uniqueness of criminal law and the unique function, the unique necessity of criminal law. The claim is made in these materials that there are sort of fundamental threats to a society's happy existence that can be adequately addressed only by criminalization. And the claim, and sort of exactly why criminal law is distinctively necessary and distinctively important varies from one source to another. But one of my examples is a famous essay from a professor named Henry Hart. The essay is called "The Aims of the Criminal Law." And it's both scholarship and pedagogical material. It is the most cited criminal law article of all time. But it also, if in the author footnote or in a first footnote, Henry Hart mentions that this article is something that he wrote for his first-year criminal law students, and he considers it a very elementary statement of the basics, obvious truths of criminal law. So in the Aims of the Criminal Law, Hart makes one version of this claim of the distinctiveness and uniqueness of criminal law by saying that criminal law is essential as the way that societies communicate the most basic responsibilities that human beings have to one another, in order to live together peacefully. He makes a sort of passing reference to other agencies of education, doesn't quite say what they mean, but he says criminal law is the most important, and that without criminal law, we essentially would, I don't know, live in a war of all against all, or in some kind of violent and chaotic place where we just didn't know that it's bad to, throw a punch at somebody if you lose your temper. I think every time I look at this essay, this Hart essay, I think very much about those children I have, the half-Canadian ones, and how much of dealing with young children is teaching the basic responsibilities for coexisting with other people in a society. I think of how much of parenting is trying to train people that you don't just throw a punch when you're angry, you don't just take stuff that's not yours. And so forth. It has never occurred to me, at least in my conversations with my children, to say you shouldn't do these things because you might get arrested, or it's never occurred to me to think that I need to call upon the resources of police and prosecutors in the criminal law to teach these basic truths. But the depiction from this scholarly period, mid-century in the United States, is that this is one of the ways in which criminal law is exceptional, is unique, is it's fulfilling of an essential function that can't be fulfilled any other way. Let me just sort of identify a couple of different exceptionalist claims, or maybe distinguish between them. I've already spoken a bit about historical exceptionalism, and again, I think I don't want to make a kind of global claim that present criminal law is or isn't historically exceptional. I think we've got to be more fine-tuned and say there are some things like incarceration rates which are historically exceptional, and other things like wide enforcement discretion or racial disparities which are not so exceptional. I've spoken about historical exceptionalism. I've spoken about the sort of claim of exceptional, you might say functional exceptionalism, or purposive exceptionalism, the claim that the criminal law serves functions or purposes that cannot be served by any other field of law, or words of parents, or other kinds of mechanisms of education and discipline. A few of the other ways, claims of criminal law exceptionalism that I want to talk about. One claim that I think just is pretty descriptively accurate is a claim of burdens exceptionalism, a claim that criminal law imposes burdens on individuals that are categorically distinct from the burdens that are imposed by other forms of law. And I think you can overstate this case. You can exaggerate the extent to which the burdens of criminal law are distinct. It's actually not the only field of law that ever, for example, takes custody of people and detains them. There is such a thing as civil commitment. It's not the only field of law that imposes monetary penalties, certainly. But the burdens of criminal law, I think, as long as we don't overstate the case, I think that burdens exceptionalism has a great deal of truth in it. That the extent to which criminal law imposes physically restrictive burdens or sanctions, the extent to which it relies on physical force, both in the enforcement process, but also in imposing sanctions, custodial sanctions, is distinctive. And I do think that the stigmas of criminal law are distinctive, that to violate, to commit a civil offense, or to violate, I'm not sure violate is the right word, but to breach private law in some sense, to breach a contract or to commit a tort. These things, it's my perception, don't carry the same kind of stigma that being a criminal does. To be a contract breaker or a tortfeasor, I think, is not subject to the same profound stigma that is attached to being a criminal. So I'm largely in agreement with the claim of Burden's exceptionalism, which was a departure point for many of the scholars trying to develop this new paradigm of criminal law at mid-century. But then Henry Hart and others would, after making this claim of Burden's exceptionalism, they then sort of moved to an argument that said, given the distinctive burdens of criminal law, we need it to operate in certain ways. We need it to live up to, we need a profound justification. We need a special justification for this area of law, given the distinctive burdens that it imposes. So one claim that is characteristic of this period is a claim of subject matter exceptionalism, that criminal law is targeted at the most profound wrongs, at the acts that really makes peaceful social coexistence impossible, that the subject matter of criminal prohibitions, of criminal laws, is a narrowly defined set of acts that are exceptionally harmful or wrongful. Now that claim was just patently untrue at the time that it was made in the 1940s and 50s. It was untrue in the earlier eras of American criminal law, and it's patently untrue today. But one aspect of the exceptionalist paradigm that I'm studying is a kind of elision back and forth between descriptive claims about what criminal law is right now and aspirational claims about what criminal law should look like. And I think that Henry Hart and other scholars writing at this time are just sort of a little bit deft in kind of moving between their descriptive claims and the aspirational ones. So the claim of subject matter exceptionalism is stated as a fact in quite a lot of this scholarship and in quite a lot of the pedagogical materials. And you can see how a belief in subject matter exceptionalism might be imparted to students who are learning about criminal law by learning about homicide, that is consistent with the view that the criminal law is sort of directed to a narrow set of really dangerous and terrible acts. So that's subject matter exceptionalism. There's also a claim of what I call in the paper operational exceptionalism. I'm not sure that my labels are the best or most transparent ones, but by operational exceptionalism, I just mean a claim that it is possible to make substantive law discipline and constrain the enforcement process here. That we can define criminal law clearly, we can write good statutes which are not ambiguous and which narrowly circumscribe the scope of criminal prohibitions, and then if we have that good substantive law, the enforcement officials, police and prosecutors, won't have a lot of discretion, and they will ideally be finding everyone who violates any one of these narrow prohibitions and bringing them to justice. We can, the possibility of sort of writing the good substantive law to discipline the enforcement process is, again, what I would call the claim of operational exceptionalism. So that's, I think, sort of the main contours of the view that I want to talk about in the paper. Again, you can see it emerge in the United States in law school pedagogy and in legal scholarship around mid-century, and then it just stays put. I mean, I think that basic paradigm has not much changed. If you look at case books in the United States, and I don't know if this is true in Canada, I would like to hear more from this, but in the United States, I don't know of a criminal law professor who teaches criminal law from anything other than a case book. There are a few professors who sort of customize them and cut and paste from multiple case books, but for the most part, there are these commercially produced case books from big companies, and there are 2 or 3 of them, all based on that Michael and Wexler case book from 1940. I mean, obviously, like, the cases have been updated and adjustments have been made, but the basic table of contents is, the topics listed in the table of contents is markedly similar. So there's a certain kind of uniformity of pedagogical approach and a consistency from mid-20th century to the present. Obviously on the scholarship side, criminal law scholarship has sort of flourished and gone into many directions, and there are a fair number of very critical approaches that are less, I think, invested in the idea that the criminal law is exceptional or that the criminal law can solve the problem of enforcement discretion, et cetera. But I do think that those lines of scholarship, although they exist, are exceptional, or marginal, and that the dominant paradigm, the dominant way of talking about and understanding criminal law is indeed fairly consistent with what we saw scholars introducing at mid-century. So I want to hear from you and have some time for questions. I just want to take a couple of remaining moments to talk about the last two parts, really part 3 of the paper, which is kind of being reconstructed as we speak a little bit. Just to say about how I think that these claims about the intellectual framework, the ideas we use to teach and think about criminal law in the United States, the connection between those ideas and our practices. I don't want to make a causal argument. I don't want to say that criminal law exceptionalism caused mass incarceration or caused America to have rates of criminal law intervention that are so much higher than what they used to be, so exceptional in comparison to other countries. But I am interested in what I describe in the paper as a question about the conditions for mass incarceration or the carceral state. So not a causal argument, but maybe one of the conditions that helped us get to where we are today. And the particular question that interests me is how little resistance there was to penal expansion in the years that it was going on in the United States. Starting around 1970, as the prison rates start, the imprisonment rate, the incarceration rate starts to climb. Throughout the 70s and the 80s and the 90s, when the enforcement of criminal law is just expanding and expanding in capacity. The rates of various kinds of criminal law interventions, arrests, convictions, the number of people in prison, but also the number of people who have a prison sentence and are out on parole, on all these different measures, all of these things are climbing throughout the 70s, the 80s, and the 90s. And throughout that period, there is very little resistance from the various segments of U.S. society that you might have thought would put up a fight. So when I, sort of think about the conditions for mass incarceration, one of the things that interests me is why so little resistance? Why did people think that this was a good idea, especially given how expensive it was? I mean, that's sort of part of and how expensive it continues to be. That's part of the story here, is that there's a huge, huge monetary investment to build this. These are sort of speculative. We're thinking here about how ideas and educational paradigms then influence what people do when they go off to be judges or go off to be practitioners, prosecutors, or go into politics. But I think that there is a sense in a lot of the discourse about criminal law through the 80s and 90s. You can see a lot of the claims about criminal law that are consistent with the paradigm I've called criminal law exceptionalism. One was the sense that, if things are terrible, there is no solution other than criminal law, that criminal law is uniquely necessary. I talk a little bit in the paper. I want to expand this discussion. I talk a little bit in the paper about some books about the role of Black majorities in urban areas like DC or New York City, where you had sometimes political divisions or subdivisions, where there was a sort of an influential majority of voters of color, where there were leaders of color, and support in some of those instances in DC and in New York for expansions of criminal law and for more severe sentencing policies. Support that was adopted with awareness that these new policies were going to be brought to bear most heavily. The burdens of those policies would fall upon young men in these same minority communities. And there's been a couple of terrific books written about this, including most recently James Foreman's book, Locking Up Our Own, a Pulitzer Prize-winning study. And one of the things that's striking about the story that these books tell is the sense of sort of desperation, in the sense that criminal law is the only way to address our criminal law is a necessary way to address problems of violence and offending in minority communities. Now, I want to qualify that, especially with regard to James Foreman's book, because James Foreman does point out to the extent to which a lot of the political leaders, people actually in some position of power who were African American, the extent to which they really didn't, at least some of them didn't subscribe to criminal law exceptionalism. They asked for expanded criminal law enforcement, but they also asked for increased funding for schools and after-school programs and better social welfare benefits, and a number of measures that might address offending, especially among youth, that don't involve criminal sanctions. So that's not an exceptionalist approach. But the dynamics of the situation, the way that it played out, was that it was only the request for criminal law enforcement that was heard and responded to by the overall political majorities across the state of New York, or even in the District of Columbia, and so criminal law expansion happened in these places with support from communities that you might have thought would have resisted it. Partly, I think, because of a sense of the necessity of criminal law, the sense that criminal law might accomplish something that other forms of law wouldn't. The other way in which I think criminal law exceptionalism is, you can sort of trace it through the expansion of American penal law over the past 30 or 40 years, is really to look at the language and self-explanations, the language of prosecutors and the explanations that prosecutors and former prosecutors used to describe what they were doing. And I think about this a lot because a lot of the people who teach American criminal law in the United States are former prosecutors, and most of them express great chagrin about the state of American criminal law right now. And they're my friends and my dear colleagues, and I don't like to say, well, what were you thinking? But what were you thinking? And I think the answer is something along the paradigm of criminal law exceptionalism. I think that prosecutors were thinking, I'm going to find the right defendants. I'm going to prosecute the right people. I'm going to find the ones who really deserve it, who really did something terrible, and I will make sure they have a lawyer and that they're entitled to their due process. But I'm going to use criminal law as an instrument for good. In the way that I was taught back in law school, in this paradigm. I don't think that prosecutors pursued mass incarceration consciously. I don't think they did it in bad faith. I think, though, that they had a competence in the nobility and the justice of what they were doing that is, in part, a product of this intellectual paradigm. I feel that I probably have spoken too long already, and I do want to hear from you. So I think I will stop here and welcome your questions. Thanks.
Thanks. This was exceptionally interesting.
Thank you.
So I like a lot of what you're saying, and I definitely think that the idea of criminal law exceptionalism is part of the story. So I want to kind of make a couple of suggestions that are broadly in agreement. So one, in the paper you say, you put the consequentialists in the same camp, and I want to speak in their defense, because but I think you can still spin the story ultimately in your way, because actually if you look, for example, at law and economics scholars, when they write on criminal law, they look at criminal law as just one more tool. So Chevelle has articles like that, Cooter, and so on. So they're really not the ones who are guilty here. But the interesting aspect is that law and economics, which is in other contexts very successful, remains very marginal within criminal law thinking.
Right.
And in fact, there is, I found this essay. So Fletcher has an essay called The Fall and Rise of Criminal Law Theory, or something like this. And he says there something like, well, law and economics hasn't really said anything useful about this field because it doesn't have anything to say about guilt and punishment. So there is a sense that, and that's exactly the exceptionalist idea, right? Yeah. That criminal law is about guilt and punishment. And as such, it belongs to a paradigm that is really not about money. And then when you move from the rarefied field of academia to the real world, if you conceptualize criminal law as about putting some kind of broadly retributivist idea, then you can say, well, money is no object. Sure, you can do cost-benefit analysis about everything else, but with respect to the moral wrong that people committed, their money is no object. And so here, I think that's sort of a broadly retributivist idea that is is there, and therefore also resistance to actually consequentialist perspectives in criminal law thinking in the US. So that's one point. The second, which I think is also broadly with part of your story. So I was surprised to see that you didn't mention James Q. Wilson in your paper. And at least as an outsider to the field, so he's sort of the representative of the collapse of the rehabilitative model and the idea that not even retributivism, the only purpose of criminal law is just to keep those bad people away. And obviously, rehabilitative idea is anti-exceptionalist, right? Criminal law is part of a broader welfarist project of making it's one more tool to help society and its members. Whereas when that collapses in the early 70s, comes Wilson as a representative of the view, no, criminal law is not at all about rehabilitation. It's just about keeping bad people away. So these are two thoughts out of many that I
Great. Thank you so much, Danny. That's helpful. So I do say in the paper that when I'm sort of sketching out this intellectual paradigm, I acknowledge that I'm not saying very much in the model I present that I think you can pull from these scholarly and pedagogical materials. I don't say very much about retributivism versus consequentialism, which, if you travel in criminal law theory circles, which I do, that's kind of, one of the main fault lines. If you think of, if your search for intellectual paradigms for criminal law is criminal law theory or criminal law philosophy, then there consequentialism and retributivism, again, sort of define the camps. And I don't say much about it, in part because in kind of searching, in what I think of as a sort of intellectual history work or searching for the ideas, I'm not really thinking about criminal law philosophy. I'm not thinking about, this is, even an even tinier subset than the legal academy, the tiny subset of criminal law theorists or criminal law philosophers. I don't think that they are irrelevant. And again, many of my dearest friends, maybe I myself am one of them, so let's try not to be irrelevant. But they're not part of the kind of broader paradigm that I'm looking at here. I really am looking at sort of what criminal law is, the way, especially the way we communicate it to future lawyers. But I will say in a second, I'm also sort of interested in ideas about criminal law that are communicated to people who never go to law school, sort of expectations of criminal law even beyond legal training. So that's one part of it, is that I'm not so much interested in kind of debates in criminal law theory as I am in the kind of way of thinking about criminal law that I think characterizes lawyers, the field of legal professionals more broadly. And I also think, one thing that I do want to say is that I wouldn't say that consequentialists and retributivists are all both criminal law exceptionalists. I don't want to make that claim. I think you're absolutely right to point out that one of the strands of scholarship that is more critical about current practices is the kind of number crunching. What are the actual empirical effects approach. From law and economic scholars and other quantitative scholars. So I don't want to make the claim that they're exceptionalists. What I did want to say is that I think that the paradigm of criminal law exceptionalism can accommodate both retributivism and some forms of consequentialist argument. I think it is important. I think that Michael and Wexler, who are writing a casebook in 1940 when rehabilitative ideas were more prominent and retributive ideas were maybe less important. They sneered at retributivism. They saw, kind of retributive just desserts theories as kind of barbaric and vengeful, and they are part of the founders of this paradigm. So I don't want to say, I just want to say, I guess, that I think this paradigm can accommodate either. Not that if you are a consequentialist or if you are a retributivist, you're necessarily within this paradigm. And then the other thing just about James Q. Wilson and sort of the rise of kind of incapacitation theories, I think that's useful, and I'll think more about it. But one thing that I didn't want to do in this paper is sort of get into the kind of argument which I think is characteristic of criminal law philosophy, in which people sort of line up behind one of their favored theories of punishment and then explain why people who subscribe to the other view are to blame for some problem. So, the consequentialists point the fingers at the retributivists, retributivists point the fingers at James Q. Wilson or others who endorse incapacitation. And, I think of these sort of strands of argument as all, I think of these as kind of the four horsemen, kind of pulling the four horsemen of the carceral state, kind of pulling it along. Some of us, some people might endorse one of these justificatory frameworks or another, but they're all justificatory frameworks. They're all, I think, a kind of ideological claim about the good things that criminal law accomplishes. And I think, if I can just say one more quick thing on pedagogy and then hear more questions, I hope. One of the things that I think is really fascinating about American criminal law casebooks is that most of them begin the course with these different paradigms. Here's consequentialism, read a little bit of Bentham. Here's retributivism, read something, read a few paragraphs of Kant and incapacitation and rehabilitation. Here are the theories of punishment. Which one do you like? Which one, which one supports this law and which one supports this law? And I always look at that part of the casebooks and I think of that New Yorker cartoon of the guy, the businessman on the phone trying to make an appointment, and he says, "How about never? Is never good for you?" I was like, "How about nothing? Is nothing? Is none of these paradigms an option?" But it's not in the approach that you see in these American casebooks. Okay, that was too long an answer. I want to hear more questions.
All right. So, Mr. Benopade.
Hi, Professor. This was really very, very rich and interesting. I really appreciate reading the paper. My question is, so to the extent that the paper is called Intellectual History of Mass Incarceration, It seems from what I've understood from your talk and from the paper is that it's very much an internal critique of criminalization that happens through law school pedagogy and that flows into prosecutorial offices, etc. But mass incarceration for me is not really a strictly legal term, it's a socio-legal term. So for instance, when you say that prosecutors who are now law professors, were very much driven by the high ideals of law school pedagogy, I would imagine that a large part of their thinking in prosecuting would actually also depend on election result, on election imperatives. So to that extent, the social has a huge impact outside of the realm of legal cases, jurisprudential theories, etc. So to what extent do you think, I don't know that much of it is in the paper, but to what extent do you think that limits this argument that this is a relatively complete history, intellectual history of mass incarceration as opposed to criminalization?
Yeah, I think that's a great question. Yeah, so suppose we had a radically different paradigm in law schools. Suppose that the influence of legal realists or critical scholars had taken law school pedagogy in a different direction. Would things be profoundly different? And I think they would be different in some ways, but I'm not sure how much. I'm not sure how much they would change, and that's one thing that I do think a lot about. I don't address in this paper is sort of how much of ideas about the necessity and dignity and importance of criminal law come from the legal academy versus other kinds of cultural sources. I will illustrate this with one more example from my kids. I have a 7-year-old son who is obsessed with Legos. I think that's probably true of many 7-year-olds in many places. But I think the American side of him makes him really, really want the Lego prison. And Lego, those little building blocks that snap together, it makes a prison. And I didn't know this until my son started campaigning a couple of years ago for me to get him the prison, which I haven't done, but he still brings it up. And this led me to really, I think, become very much aware of how criminal law, crime and punishment is presented to children through toys, through things like the Lego prison, which I understand. I mean, apparently Lego police sets, the criminal justice side of Lego is apparently a very popular selling line, at least in the United States. I don't know how it compares elsewhere. It really made me, it's really made me sort of tuned in much more to depictions of crime and criminals to children. So yes, I think that if you were really going to do a true history of the ways that we think about criminal law that looked, sort of at all the influences, I think it would certainly look far beyond the legal academy. It would look at not just, I mean, you mentioned elections, not just, sort of politics and political dynamics, but look at culture and the extent to which, one thing that I find really interesting is the extent to which the sort of, that kind of fundamental dramatic conflict between good and evil, between protagonists and antagonists, that sort of fundamental conflict which sort of drives literature and movies and our sort of cultural stories from at least ancient Greece, if not earlier, that sort of conflict, the good-evil conflict, it is so, I'm now struck by how much in the United States it seems to be defined by cop and criminal, by an antagonism of that we see through the lens of criminal justice. Why is it that the superheroes like Superman and Spider-Man or Batman, why are they crime fighters? Like, can't you make them a villain, some sort of, this is fantasy after all, can't you make them some kind of villain who is independent of the trappings of the criminal justice system? But they are crime fighters. So I think that our, sort of a real effort to understand all of this would have to look a lot broader than just the legal academy. That's future work. I can't do that here.
Professor Canove.
Thank you. It's great pleasure listening to you. I raised two sons, and then both of them were interested in the the criminal justice component of the Lego, but luckily it doesn't come with victims or criminals. It just comes with the police and the car and whatnot. So at least saving graces. But what I wanted to ask you was the business of mass incarceration. So within the legal academia, and especially the professional training of the law school students, I was wondering how much space that could be allocated within the actual curriculum, because at the outskirts of legal academia, in criminology, law and society, politics of law, that is the starting point for us. That's how we actually start lecturing on criminal justice system. But when you're in effect training lawyers to do the job, do you see any space for that to be included?
You know, it's interesting. Yeah, so you can imagine, I guess, you know, were Herbert Wexler alive today and responding to me, I guess, you know, one response might be all of these sort of cultural or social aspects of criminal law, putting criminal law into social context. You know, that's fine for you know, you to do in your fancy seminar, but when we're talking about a law school curriculum, we have an obligation to practitioners. One interesting thing to say is that is not the account that Michael and Wexler gave of what they were doing. They did understand themselves to be training lawyers in a sense, but again, they were pretty explicit that they were not trying to recruit new prosecutors or defense attorneys. They viewed the kind of practice of criminal law as, again, a grimy business. And they were at, you know, they were at Columbia. The other influential people that I'm talking about are at Harvard. Columbia and Harvard, you know, they wanted their graduates to go practice private law and make lots of money. At that time, they were not, again, seeking to cultivate practitioners. I think that a lot of that has changed precisely because this intellectual paradigm brought so much more dignity to criminal law. So now, you know, I think law schools in the United States do, you know, encourage students to especially become prosecutors, especially federal prosecutors. I mean, it's a very prestigious job, and law schools are proud to push people in that direction. But I don't think, so I guess, you know, one thing is that I don't think that the, I guess I'm not worried that the job of producing lawyers kind of forecloses these kinds of inquiries or makes them impossible. I think that this paradigm wasn't really created to train lawyers. It was trained to sort of burnish the field and bring respect to it, but not to actually, you know, enable a law school graduate to walk into a courtroom and defend somebody on a drug possession charge. I mean, a law school graduate has never thought about drug possession charges if they take a criminal law course that's based on the Michael and Wexler casebook.
Let me answer myself on the list and then move back. So just start with a little comment. I'm trying to think to our casebook. We have two dominant casebooks in Canada, and we're having this argument here on faculty as to which one we should use. And the one that's been in circulation for the longest time is exactly a casebook like the kind you mentioned. It's a substantive criminal law casebook. Mm-hmm. The alternative, though, is not a casebook that includes, you know, forms and more bread and butter kind of lawyering stuff. It's a textbook that includes, in addition to substantive criminal law, some procedure, but procedure that is tackled still at a very academic level, right? Given the constitutionalization of criminal procedure and so forth. So it's interesting what you're mentioning, and I'm wondering whether, you know, we're not seeing in this country kind of a return to something a bit more like what you were saying. My question is a bit broader than this. So I'm wondering whether there's a prescription coming out of this paper, right? Because so there seems to be an indictment in some of criminal law exceptionalism in many of these of its forms. You say it's not a causal story, but you still tie it to mass incarceration, which I take it you don't think is necessarily a good outcome of this. So what's the prescription? And then I'm driven to think historically about where it all started, right? So criminal law was not exceptional when it started, right? It was basically tied up with the rest of law. And you had this accused speak model where the outcome could be, well, you need to pay money. We're more the tort paradigm now. And then another outcome could be, well, we're going to detain you, or whatever, what we now think of criminal law, but it was very informal, etc. And at some point in the story, you said one kind of exceptionalism you seem to think has some truth to it is this idea of burdens exceptionalism, right? And it seems to be burdens exceptionalism that took us away from this accused speak model, right? Introducing defense counsel, introducing prosecution, just because of what was hanging in the balance and all the problems that were there with the more informal model with people lying, etc., right? Mm-hmm. And then that led further down the road to the professionalization of the police, and then the Supreme Court, both in the US and Canada, wanted to seeing how much of an expansion there is of this, try to regulate this at a constitutional level, right, the Warren Court, and so forth. And so the worry here is if you acknowledge burdens exceptionalism as being true in some form, don't we inevitably end up with a story like the one we have, right? Mm-hmm. Or what would be the alternative, as it were? So it's tempting to ask that question given the title, right?
Great. Well, how about nothing? Is nothing good for you? I don't.
The war of all against all.
Well, but see, I have some skepticism that the war of all against all is the result if we stop relying on criminal law or stop expecting criminal law to solve our problems. In fact, I've heard a number of activists and advocates in the United States point out that the sort of horrors that people point to if we were to stop relying on criminal law, murders and thefts and abuse, they exist. It is not the case that criminal law has solved those problems. So I think that's a good question. The prescription coming out of this project, I have kind of some narrower prescriptions or aims, and then kind of a looser, bigger one. First of all, I do think pedagogically, the pedagogy of criminal law in the United States should change dramatically. And that's sort of something that I don't want to spell out too much in the paper or too much right here. That's sort of another aspect of my job, but that is a big project that I'm engaged in with some other criminal law professors, and I do think there's a hunger, especially among people who started teaching criminal law in I'd say the past decade in the US, a hunger for a different kind of criminal law course, a different curriculum. I don't want to have to try to create it all by myself, but that sort of a different pedagogical approach. And the different pedagogical approach, just to sort of give a gesture at a few aspects of it, it is largely anti-exceptionalist with respect to the operation of criminal law. So it emphasizes discretion much more, the same discretion that you find in administrative law or other fields. It emphasizes that much more. It does not focus on homicide as the paradigm crime. It places a great more of emphasis not just on drug offenses, but on sort of public order offenses, misdemeanors, the kind of low-level offenses, which are the vast, vast majority of criminal law interventions in the United States. So there's some pedagogical differences, but then kind of some pedagogical changes that I think we have to pursue in the U.S. But then there's also this sort of question about the how about nothing or how about never question. There is increasingly, as I said, conversations in the United States about criminal law have changed a lot in the past few years, and one of the ways in which they've changed is that people talk about abolition and use the phrase abolition with respect to prisons or with respect to criminal law generally or with respect to the police much more often. And I still am sort of unsettled on that phrase or that paradigm, in part because in addition to being a criminal law teacher, I'm a constitutional law teacher, and I think of abolition very much along the paradigm of the abolition of slavery, and it's hard to sort of think about how that would translate to criminal law. With the abolition of slavery, you had a federal government kind of enforcing a abolition on subsidiary institutions, and I think that if criminal law is radically to shrink or change in the United States, it's going to be much more a bottom-up movement rather than some kind of top-down, I'm the authority and I now abolish this. But I do welcome without necessarily welcoming the particular phrase, I do welcome this broader discourse that really questions, whether criminal law is as necessary and fundamental as we've been making it out to be.
So we're just going to go around and come back.
Thank you. Thank you for the talk. I come to this from a completely different background. So my background isn't in law or criminology at all. It's just something I've developed an interest in the last while. And listening to you talk from that perspective, I wondered if what you're talking about isn't really in the history and sociology of professions, as it were. And what I couldn't help thinking of is this is the effort of a professional group or a sub-professional group to build its own status. And this is something you see very commonly. I think if you looked at this, say, the history of psychiatry in the early days, you'd see the same thing. And because it's about the sociology of the profession, it doesn't actually have to have any connection with the empirical world at all. It's not really about whether it works in the empirical world, it's whether it works in the world of status, hierarchy, and respect that professionals engage in. So I just wanted to put that out there as another potential way of thinking about the questions you raise.
Yeah, that's useful and helpful. I mean, I think that is part of the story. I think it is an effort to build professional status. I do think at the same time, though, it is important to see that this profession is deeply invested in claiming to be important to practice, to the empirical world, claiming to take empirical realities into account, and claiming to offer proposals that are going to change or shape practices. Now, the degree to which those claims are borne out is questionable, but I think I would add that to your description.
So I want to pick up on sort of pedagogical questions and kind of reflections and think about, so I don't teach criminal law at all, but in two respects, in the sort of context of the sort of poverty law clinic and also in terms of labor law, two areas that I work in, you see how assumptions about crime and punishment seep into and inform the origin stories of other areas of law, right? Mm-hmm. And so I guess I'm looking for some help on that and thinking about that. And when I kind of listen, there's lots really interesting and important about what you said, but I was stuck on this kind of point where you said there was little resistance, how shocked you were about how little resistance there was to penal expansion in the 70s onwards, which seems to me a shocking claim. Because that may be true within law school, in the sort of law school accounts, but certainly social movements, there were certainly counter understandings of crime and punishment and rejections of it, right? So whether we talk about sort of prisoner rights sort of stuff going on, and Attica as a sort of a classic example, or we talk about the Black Panthers as a sort of a radical challenge to conceptions of crime and punishment, seems to me that those are missing from your account.
Yes, good.
So then that means to me, so I think there's a bunch of things to say, including like, okay, what do you mean by intellectual history? And I think that's what someone was trying to get at earlier. Are we just talking about an intellectual history from within law schools and how we tell each other, about what we're teaching and so on, and then the students that circulate through them? Or are we trying to pedagogically now bring in a different kind of account? And if so, would we turn to sort of social movements and those kinds of accounts and look at the longer history of social movements and see within them different kinds or even counter assumptions about crime and punishment? That would go back even further than the Black Panthers or Attica, and actually it would seep into the stuff that you were rejecting earlier in terms of constitutional versus criminal and abolitionism, because throughout different kinds of abolitionist strands we see, again, alternative accounts of crime and punishment, not necessarily always top down. So I guess all of that packaged together, I'm trying to get a sense of how to kind of come at these things as someone who doesn't teach criminal law, but sees it seeping into all of these other areas, the assumptions about crime and punishment.
Okay, good. Thank you. That's really helpful. I think I have to think about my phrasing if you took the point as the absence of resistance to incarceration, period, rather than the absence of resistance among politicians who held power or among sort of elites with the power to influence policy. That's the absence of resistance that's interesting to me, because I do think that polarization in America has ebbed and flowed, and but it's always been there. And on most major new policy initiatives or major federal legislation, there are arguments. There are, arguments within the people in Congress or within the people in the state legislature. And so when I say the absence of resistance, I mean the extent to which we had this sort of steady expansion of enforcement capacity without cutbacks, without, a fiscal conservative bloc saying, no, we've got to cut prison funding, we've got to close some prisons because this all costs too much money. That's the kind of non-resistance that is of interest to me here. Yeah, I think low-level resistance, the people sort of bearing the brunt of this have been resisting all along. And the ways in which both individual criminal defendants, but also family members and members of their communities have resisted criminal law interventions is something I have written about in other projects, something that a current colleague of mine at Brooklyn Law School writes a lot about. So I definitely don't want to suggest that that sort of grassroots or non-elite resistance doesn't exist or isn't part of the story. I have another project right now about prisoners' rights doctrine and prisoners' rights, addressing prisoners' rights movements in the United States. And I have to figure out whether any of that story also needs to become a part of this account. Maybe your suggestion is that it should. But I definitely, I think, want to agree with you about the continuity and importance of low-level resistance. We're still left with the question, though, why those arguments, why, for example, civil rights-based arguments, sort of racial justice-based arguments, didn't capture progressive politicians or legislative majorities that might otherwise have been very concerned about the penal expansion, especially the racial disparities within it. And I do think that exceptionalism, this exceptionalist paradigm, has some role to play in helping us understand why. The racial disparities in the U.S. prison population have climbed over time, but they were there before the prison population started climbing so quickly in the 1970s, and they continued throughout the expansion of the prisons. And they weren't unknown. They weren't a big part of the discourse, but they weren't unknown. We have various federal institutions that track these things and send out their data, and there were occasionally reports or discussions. But they didn't become a really big part of the conversation. They didn't become something that was sort of leading everybody running for president to decry racial injustice in the criminal justice system until past 5 years, maybe past a decade or so. So I do think that is, again, a question we have to tackle. Why the kind of the most powerful, the actors with the most influence over policy, why they were able to coalesce around criminal law's expansion rather than seeing, kind of more dissensus within those elites.
Thanks very much. It was a fantastic paper. I just have a question about whether it itself is an exceptionalist story of what's happening. And I want to ask a broader question about legality or various conceptualizations of legality over time and power, essentially. So from the 18th century on, we've had notions of legality masking some sorts of power relations. So it seems to me to say that within a law school within the 40s, if we're using certain theories of criminalization or what is criminal to mask what's happening on in practice, isn't that a broader feature of how various conceptualizations of legality or procedural justice were operating at the same time?
Yes, I think that's true. I think that, yeah, I think that, I mean, I don't know whether the United States is exceptional in this regard. You can tell me how it compares to Canada, and we can speculate about other countries. I definitely think that it's true in the United States, whether or not the United States is exceptional in this way. It's true in the United States that there's a very, very deep investment in law as something that can be separated from discretion and from just political power, the rule of the stronger, or the exercise of might. And so the effort to explain how that is and give an account of law that is, again, separate from politics and political strength and socioeconomic power is characteristic across legal fields in the United States. It's definitely not specific to criminal law. I do have the sense, I mean, I teach both constitutional law and criminal law, so I don't teach private law subjects, but I do have the sense that criminal law is unique in the extent to which it has kind of resisted the sociological or socio-legal critique or the sort of critical, the critical legal studies movement in the United States. One of its aims was to bring to the surface ways in which what we think of are, legally necessary outcomes or legal concepts are really instantiations of and vindications of various power relationships. And I don't know how influential critical legal studies was across different fields. My sense is criminal law is the place where it had the least impact, where the kind of scholarly and pedagogical paradigms were sort of most invested in vindicating the idea of the possibility of the rule of law. I talk about this a little bit toward the end of the paper. The very phrase, the rule of law, at least in the United States, again, I don't know if we're exceptional on this, the rule of law, we are deeply invested in the idea of vindicating the idea of the rule of law, which is different from the rule of man, the rule of men and women, and the rule of human beings. So we're deeply invested in this idea that, again, sort of law can be made impersonal and independent of the individuals who act as the agents and enforcers and the implementers of law. And I do think that is that claim is more pronounced in criminal law than in other fields of the United States, but I definitely don't think it's unique to criminal law.
Thank you so much. This was fascinating. And I found it particularly interesting because I'm a relatively new criminal law professor teaching what I realize is a retro course, I guess, that I'll continue thinking about. But I did my graduate work in the States with a comparative sort of angle. So I attended some sort of JD crim classes in the States. I don't know that I would sort of describe the two as very different, but certainly it's still interesting from that perspective. And I wonder, it struck me as you were speaking about Burden's exceptionalism and the sort of various moments in the history of American criminal justice where there was a rallying around criminalization as a way of addressing sort of real or perceived social problems. I remembered an experience sitting in a JD class in which we were discussing prosecutorial charging discretion and whether we would, as a class during this exercise, want to bring charges in this hypothetical case involving like a mom who'd tragically forgotten her baby in the car, right? Mm-hmm. And a really big percentage of the people took the view that a child has died, so of course we need to bring charges. Like there was this view that because there was a terrible outcome, that would itself sort of be a complete reason for using criminal law power. And it struck me that that impulse, which was present among these like quite elite JD students, and also seems to be one that's general to society. And I mean, we see it here, like we've got criminological research in the Canadian context about instincts that people have that mandatory minimums are going to be effective for crime control, right? Yeah. It seems to me like there's a way in which burdens exceptionalism actually is the justification as opposed to the need, like it's something that requires justification. Like there's a sense in which it seems that there's a popular conception that because criminal law carries such heavy burdens and stigma, it is an appropriate and useful tool for addressing problems, right? And that's a story you can tell either from a retributivist or consequentialist perspective, right? Because there's this sort of, I think, largely wrong but widely held belief that heavier burdens will, have more sort of desirable effects in terms of social conditioning, right? Or perhaps a more retributivist account. But it seems like there's perhaps a narrative where burdens exceptionalism is precisely what's good about criminal law. And then what we require is not something to justify criminal law by virtue of the burdens, it's just to ensure that it's being applied appropriately, which is why we then generate all of these procedural matrices, which then, as Langbine has talked about, we then swiftly circumvent through processes that are not talked about in most law schools, right? So I think a lot of students could be forgiven for leaving law school thinking that everybody is getting a soup to nuts criminal trial with lots of procedural protections, and that that's what's going to help us make sure that this is only being used in cases where it's really needed, i.e. cases where we have a problem to solve, right? I don't know if that has any sort of, if that can actually latch on at all to the very careful historical narrative you've constructed, because this is impressionistic on my part, but I'm curious as to your reflections on it.
I think that's very helpful. I think you're probably right that it is the distinctive intensity, the physical nature of many criminal law sanctions, and the profound stigma that's attached to them. I think that those things are, you're probably right, that for many, not just within law schools or people who've been trained as lawyers, but sort of across society generally, those distinctive aspects of the burdens of criminal law are part of what people appeal to when they call for criminalization. And so that sort of leads to, I guess, kind of a broader question about mechanisms of condemnation. This is something that I have been thinking about over the past year or so in the United States, watching conversations around the Me Too movement. And one of the really interesting things about this sort of this social protest against sexual harassment and sexual abuse in the United States over the past year and a half, which has I think, I guess, maybe empirical scholars will measure it someday. I think it's been fairly influential. I think that it has, really changed the way I can see it in my own interactions. I think it has changed the way a lot of people think about interactions in the workplace and elsewhere. And one of the really interesting things about Me Too is that while I'm sure that some of the voices speaking out against sexual harassment and sexual abuse, some of the people raising complaints or telling stories of past abuse, some of them do want the criminal law to intervene. Some of them say, it's ridiculous that Harvey Weinstein hasn't been prosecuted and convicted yet. But a lot of the sort of force of condemnation that has come out of that movement, it's already there. The condemnation has, the sort of the message of social condemnation of sexual harassment and sexual abuse. The message of condemnation has been communicated, I think, relatively forcefully and maybe more effectively than sort of official legal sanctions or criminal law sanctions for rape, which I think never have proven to be particularly effective. Yeah, I do think that you're sort of right, both in your observation that the burdens of criminal law, including its stigma, are seen as one of the things that make it necessary and important, and particularly justified in some senses. But I guess I would say also, as we sort of think about, Francois' question about prescriptions or going forward, maybe one of the things to think about is whether at least the condemnation side of criminal sanctions does actually require criminal sanctions in their current form.
Thank you very much. I think my question in some ways might track back a bit to Adrian's question and ideas around resistance by whom. So I am also not a criminal law scholar, and some of the way I come at this as well is through work in poverty law, social welfare. And so as the conversation has unfolded, I've been just trying to think a bit about how some of these ideas might map onto or not. Some of the literature related to neoliberalism from the 70s, 80s forward. And in particular, ideas about both rollback and roll out forms of neoliberalism. So the idea that the state is withdrawing its presence in particular kinds of fields of regulatory activity. It's less present in some areas, including in the distribution of lots of different forms of what we might broadly call social welfare areas. But it's rolling out functions in other areas. And these are not unrelated. And that affects who are the populations that are affected. And where it's rolling out is law and order. And it's rolling out law and order, not just in the formal criminal law realm, but it's rolling out law and order in the distribution of social welfare, sometimes related to immigration. So in a whole bunch of other fields. And it's also where I think both in the US and Canada, we see some of the expansion of the criminal law itself, things that weren't criminal become criminal. But another part of that is around enforcement and surveillance. So who are the populations that then become much more subject to surveillance? So the rollout and the rollback, as I say, are connected. And in this context, many would argue, I think, that lots of the political elites have really used fear as the justification for the need to resort to the criminal law. And they might actually, I think, often deploy the idea of criminal law as necessary and efficacious. But some would say that the fear is constructed, I guess, at extreme moral panics, is all part of a larger kind of political strategy. It's a way in which the government, who no longer has a lot of regulatory control in some areas, is trying to demonstrate to the population that we're necessary, and here's where we're doing a good job because we're making you safer through the criminal law. So we often get statistics that are dramatically misrepresented by government actors as a way to make us feel less safe and feel the need for the criminal law, again, seeing it as efficacious and necessary. So I guess in all of this, it seems to me that the neoliberalism has a role both in relation to mass incarceration, but also maybe has some important connections to the story that we tell about the criminal law.
Great. Yes, I think you're absolutely right. There are actually a few scholars in the U.S. who have developed arguments very similar, I think, to what you have just said. And I think I'm telling a story that I think is consistent with all of that, although I'm sort of looking at a slightly different facet. But I think it definitely is true. I mean, a number of people have sort of observed that in comparison to many other developed democracies, the United States actually has a kind of relatively weak state in some regards, sort of on the social safety net or provision of social welfare benefits, but it has an exceptionally strong penal state, an exceptionally muscular penal state. And a couple of people have suggested, as I think you are, that these things might be connected and related to one another, that maybe some of the social circumstances that we think that produce crime and criminal offending, that makes people think that criminal law is necessary. Maybe some of them are related to the relatively weak aspect of the welfare state. I guess just the kind of the one. Again, I think there's sort of a literature that's largely consistent with what you're saying, and I guess the one question that arises in my mind when we observe these things is, again, why wouldn't decades and decades of state expansion on the criminal law side and increased funding, increased expenditures on this side, why wouldn't that produce more disagreement among, again, leaders, among state legislatures, or people who are actually voting on these bills? Why wouldn't, given sort of this strand of libertarianism, or vindications of limited government, or suspicions of big government, that you can see in many areas of American politics. Why is it only now, and I think now we finally do see it in the past 4 or 5 years, sort of campaigns for criminal law reform from Republican and right-wing organizations and institutions. It's only in the past few years that I think you really began to sort of see the small government critique of American criminal law among people with money and votes to make a difference. So I still do wonder why that took so long to emerge.
Hi, thank you. I just have 2 questions, sort of out of the blue, I guess, if that's all right.
Yeah.
One is, so I work on immigration detention, and I haven't heard you mention the incarceration of migrants, but it does track with a lot of the concerns that you have around racialization and class and gender, especially. You can see the expansion of the legal architecture as well as the physical architecture blooming like after the 70s and then really ramping up in the 90s. So I just wonder, I know it's in a different part of law, but the criminal capture of people often leads to the administrative or immigration punishments, right? So it's like civil punishment for criminal behavior, and often the criminal behavior, as you rightly point out, are misdemeanors. So like drunk driving is very common, or bar fights, to lead to longtime residents being detained and then sentenced to deportation. But then I also had just a question about your method of intellectual history, because I thought it was really great when you were talking about prohibition and sort of this flow of the socio-legal, sort of if there were kind of shifts in the social context that then influence these intellectuals who then influence back into the culture. So I'm just wondering how you're sort of taking advantage of that. People like Leah Yipee have written books about this, about like radical thought, and I know you're also a political theorist, so about how political thought gets motivated by activists, and then activists take up thought, and it's kind of this back and forth. And if you think there's any merit in that, I wonder if maybe Ava DuVernay's The 13th could be an explanatory factor in why you think there's been a bit of a sea change over the past 5 years. So just on immigration detention, people had never heard of this until it came into popular culture more, and also obviously with what the American government is doing at the border right now and the separation of children. But only to say that these intellectuals whose thoughts you are very interestingly tracing, they must have, what do you see as their relationship to like the outside events, and if you see catalyst events outside the law school feeding back into the law school as well?
Great, thank you, thank you. On the first point about immigration detention, I don't say very much about it in the paper. I mean, I did try to, as I kind of give my qualified acceptance of the claim of Burden's exceptionalism, the reason why I think it's qualified is, I did want to emphasize that I don't think that criminal law is the only place that confines people or uses kind of physical control as a direct mechanism of accomplishing its ends. And so, I mentioned civil commitment and passment, but obviously immigration detention is an example of that. I do think that there are ways in which kind of animus, both racial animus or animus towards outsiders, animus toward people perceived as a threat, is very prevalent across both the most punitive public attitudes with regard to criminal law and with regard to immigration policy. I do think that in both criminal law and in conversations or discourse on immigration in the United States, these fields are not so much necessarily among law professors or in law schools, but sort of in public discourse. I do think that both these fields are places where you see a sort of recurring fantasy of just solving problems by using, superior physical force, containment. I think that's what the wall is, and that's why you have to call it a wall, and why we actually need to see it go up. It's just sort of, again, sort of a fantasy that we can make things better through sort of restructuring our physical world and physically detaining or controlling or confining the people who we see as problematic. So there's a lot of continuity there, and I agree with that. On the method here, I always get nervous when people ask me about my methodology. I am, trained as a political theorist from a department that does, I think, what many people in it would characterize as something like intellectual history. A PhD program. I did a PhD in a program where it was really all about the history of political thought. But I still get very nervous when anybody asks me about methods. I think with regard to methodology and sort of everything I write, I really have just one simple motto, which is I need all the help I can get. And I'm sort of curious about empirical data or quantitative research. I am very curious about historical questions, but how do you actually sort of trace the kind of relationships between ideas and practices that I think we sort of generally characterize as part of the work of intellectual history. We're trying to sort of see how history was influenced by ideas or the way that ideas evolve over time. My method, I think, is again to read everything that seems like it might be helpful. I don't have a primer for the right way to do this. I do think that the question about not necessarily pop culture, but sort of culture beyond legal professionals is a really important one. I do think that it's true that the experience of prohibition soured many Americans on criminal law for some time. And it would be interesting to try to see what particular events. I don't know if it's 13th or I think Michelle Alexander's book, The New Jim Crow, is enormously influential, read by many people outside of the the legal field. It is, I think, a good question, sort of what cultural influences have shifted the conversation in the United States, if indeed the conversation is shifting. I think there are probably many influences, although I also think that there's just a sense in which the system is sort of collapsing under its own weight, that the number of people who have convictions or who know someone with a conviction we're less and less able to sort of tell the subject matter exceptionalist story that criminals are really distinctive and exceptional and, you know, totally evil, different from you and me. We're less and less able to tell that story as the breadth of the system and the number of people affected by it has expanded.
Great. So I think we are actually just about time. Sorry, was there? Oh, camera. Yeah. Great. Sorry. But behind you, you will find a swag bag, I believe.
Oh, yay. Hooray. Thank you.
So on behalf of those of us at the Nathanson Center, we want to thank you so much for this hugely engaging talk and paper, and we hope that you'll come visit us again soon as well.
Okay,
so
thank you
very
so much. Thank you, and thanks for your comments. Very helpful. Thank you.